voice and an empty gas can. My car's broken down a mile behind, and I've got my life set on rewind, baby. I ain't got no plans, just a rusty voice and an empty gas can. My car's broken down a mile behind, and I've got my life set on rewind, baby. Street, saying hello to the people I meet, and I'm killing my love underneath the sun, triggering down like the smoking gun. Yeah, I ain't got no plans, just a rusty voice and an empty gas can. My car's broken down a mile behind, and I've got my life set on rewind, baby. I ain't got no plans, just a rusty voice and an empty gas can. My car's broken down a mile behind, and I've got my life set on rewind, baby.
Alright guys, that was Streetwalk Manifesto by Techno X. As we go ahead and transition into what we got going on here. Yes, no sleep. I'm been stuck on this vampire kind of sleeping schedule. And at the same time, while doing this, I was like, I need to test something out here. And it seems that it's working, at least on that part. I need to check something out on my cell phone there. But, yeah, we just been, I've been spending a good portion this evening going over a very interesting case. We might as well go ahead and bring that up and transition that in so everybody can see it. I ended up learning about this from Reddit, of all places. Am I free to go? And TechDirt's been killing it with a bunch of legal stuff that's been popping up as of late dealing with civil rights. And let's see, hello, I'm driving truck, so I can't comment. Be careful with that, man. And it looks like it's doing exactly how I need it to, so I need to do a few more experiments before I can set that up, because I'm trying to set up an events thing going on and get that to work properly with the overlay, chat overlays there. But, alright, let us go ahead and dive into the big stuff. Nothing much, R. Garcia, except a very interesting case that does apply to the people like, what was it, Time to Stand and a few others that went and filmed over the Pedestrian Bridge in San Diego. Now, TechDirt has this article, court says, Customs Border Patrol likely violating First Amendment by forbidding photography from publicly viewable border crossings. Now, this was written by Tim Cushing, and it goes over a brief instance of what this is all about and what's going on. The basic gist of it. Hey, PNP, you're gonna love this. You're gonna love this case that I'm gonna read to you, man. A middle of the night case that I've been spending a lot of time this evening researching. Now, the basic gist is two parties are suing Department of Homeland Security / Border Patrol over issues of them detaining people for filming from a pedestrian cross bridge. Now, I will be putting in the links, obviously, a little bit later on, so you guys can do your own research. But let's go ahead and scroll this up, because I really want to read the important parts at the beginning of this. That is very, very important. Let's see, get it up here. Okay, so first one, the incidents that is at play, and guys are gonna love this. Ray Askins is a U.S. citizen concerned with environmental hazards in Imperial County and near U.S.-Mexico border. He has a special interest in the effect of emissions from vehicles idling in the inspection area at the ports of entry of California on air quality. In April 2012, Askins sought to photograph the secondary vehicle inspection area from Calexico West port of entry in connection with the conference presentation he was preparing on the health impacts of border crossing. When Askins called CBP to request permission, he was told by an officer that he would be inconvenient, but his request was neither approved nor denied. The next morning, he informed the officer by voicemail he would be photographing the exit of a secondary inspection area from the street outside instead. The exit of Calexico West secondary inspection area of port of entry building exterior are visible from streets on or near the port of entry from the Granero Teco Monterey Memorial International Border Friendship Park, a small park. On the afternoon of April 19th, Askins stood outside the intersection of First Street and Pauline Avenue on the U.S. side in front of the park. He was approximately 50 to 100 feet from the exit of the secondary inspection area. He had not crossed the border nor otherwise passed through the border security to reach the location. Standing in the street, Askins took 3 or 4 photographs of the exit of the secondary inspection area. Multiple CBP officers approached Askins on the street and demanded he delete photographs he had taken. When Askins refused, the officers threatened to smash his camera, then searched and handcuffed him, confiscated his property, detained him inside a secondary inspection area building. Askins was released after approximately 25 to 35 minutes, and his property was returned, at which time he discovered CBP had deleted all but one of his photographs of the exit of the secondary inspection area. Naughty. I see we have some naughty CBP people. Askins alleges that he wishes to photograph matters and events exposed to the public view from outdoor exterior areas of the Calexico port of entry and in the area immediately surrounding the Calexico port of entry building. Specifically, vehicular traffic and CBP officers engaged in the public discharge of their duties in order to document air and other environmental pollution as well as human rights abuses. He claims that he now refrains from doing so in light of CBP policies and past enforcement of those policies against him. Now, let us go ahead and look at the map here. First Street and Pauline Avenue, which I believe was right over here. No, that's Rail Court, because this is the train that runs in. And Montgomery, or was it over here? What's the name of this one? Chamber of Commerce? No. Well, this is the Calexico border crossing area. Yansan Davo. I'm okay, so I'm not exactly sure where this is at. Thank you, Spy Team, for going ahead and posting that there. Yeah, I did have that. I'll be posting the links a little bit later on when this processes. But I think it was probably somewhere over in this area. The thing is, which we'll read about in Incident 2, this pedestrian bridge is actually a new build. And he was standing in the street. Now, the only places that you can really stand and film this area is either from over in this general area, elevated, or somewhere over in this general area. This is probably a little bit older here than this photograph is probably, aerial photograph is probably about 8 years old, I think, because like this construction over here is already done. This is all parking lot when you go in the street view. John Montgomery Freeway. But let us go ahead and read incident number 2 here, which is going to be even more interesting here. Christian Ramirez is a U.S. citizen and policy advocate who works on human rights issues in border communities. On June 20th, 2010, and I believe this other incident happened around 2015, incident 1, because that seems when this all went through. Is a U.S. citizen and policy advocate who works on human rights issues in border communities. On June 20th, 2010, Ramirez and his wife visited his father in Mexico, parking on the U.S. side of the border and crossing through the San Yarado port of entry pedestrian entrance. They crossed back to the United States later the same day. After they had passed through the inspection, the Ramirezes crossed a pedestrian bridge over Interstate 5 to return to their vehicle. While on the bridge, Ramirez observed a male CBP officer at a security checkpoint below, inspecting and patting down only female travelers. Concerned that the officers might be acting inappropriate, Ramirez observed the checkpoint from the bridge for 10 to 15 minutes and took approximately 10 photographs with his cell phone camera. Ramirez and his wife were approached by men who appeared to be private security officers. The men ordered them to stop taking photographs. The officers also demanded their identification documents, which Ramirez refused to provide, as they had already passed through border inspection. Yasadrao. I'll try to remember how to pronounce it. I'm not good at pronouncing things. The officers radioed for backup as Ramirez and his wife walked away. At the bottom of the bridge, Ramirez was met by 5 to 7 CBP officers. The CBP officers questioned Ramirez, and without Ramirez's consent, a CBP officer confiscated Ramirez's cell phone and deleted all the photographs Ramirez had taken from the bridge. A U.S. Immigration and Customs Enforcement officer confiscated Ramirez's passport and walked away, leaving Ramirez surrounded by CBP officers. After 10 to 15 minutes, their documents were returned to them, and Ramirez was allowed to leave. The pedestrian bridge from which Ramirez took the photographs has since been replaced. The new bridge runs east to west, passing over Interstate 5 to connect the San Yasirado Boulevard, Transit Plaza, and Caminos Way, both on U.S. sides of the border. Plaintiff alleged that the bridge is open to and used by public to cross over Interstate 5, and that the members of the public can do frequently cross the bridge without crossing the border or entering or exiting the port of entry. The outdoor vehicle inspection areas in which CBP conducts primary and secondary inspections at the San Yasirado port of entry are visible from the new bridge. Ramirez alleges that he wishes to photograph matters exposed to public view, including CBP officers engaged in the public discharge of their duties from the new pedestrian bridge. The San Yasirado Boulevard Transit Plaza, and the footpath leading from the Transit Plaza to the border. U.S. government signs posted at these locations prohibit any form of photography. This is incorrect because the way it's worded, and we'll get into that. Remember, this is 2010. Phone encryption was on the back, not on the forefront of everybody's mind, this specific incident. But yes, I do agree, phone encryption needs to become more widespread. Ramirez claims that he now refrains from documenting matters and events visible from these locations in light of CBP policies and the past enforcement of these policies against him. The plaintiff, so actually 2012. Plaintiffs filed suit in October 2012. So this is like shortly after the 2010 DHS memo that came out. Sanya Cedra. Yeah, I'm not good at foreign languages. So you can expect me to completely butcher all these Spanish pronunciations here. and names. But we get an idea of what is going on with this location. And as he stated, this is a new bridge. He wants to film from it. Now, in the last 8 months, Time to Stand went and filmed, and California Guardian also filmed. Now, California Guardian went and filmed this location. Let me double check to make sure this is going to full screen where everybody can see it on that. Oh, excellent, excellent. And did the chat system stop working? Oh, what do you know? That's not good. Hold on, guys. Let me fix my window. Capture, transition. I'm sorry. I had the chat overwritten there. But, okay, back to the thing. Now, California Guardian went and checked, and they had the general GSA signs at the, before you cross over on the civilian side here. Or on the west side.
I'm over here with Dave, just Dave. We're on this bridge, which was used, where the guys with the cameras got pushed off the bridge.
But this is the generic GSA, has the
Except where security regulations, rules, or
and here he repeats it. Here he states it. Whoops.
except where security regulations, rules, orders, or directives apply, or the federal court order or rule prohibits it, persons entering in or on federal property may take photographs of space occupied by tenant agency for non-commercial purposes only with the permission. Space occupied by tenant agency for commercial purposes only with written permission. Building entrances, lobbies, foyers, corridors, or auditoriums for news purposes. So C applies. So that would be 41 CFR 102-74420C. All right.
Now this is on the west side here, and thank you, California Guardian, for doing that, because it made my research a lot easier. Because when I was trying to figure out what signs were posted around this area, and these pictures are fairly recent. This one here from Public Street View, December 2016, not too long ago. And if we sort of scoot over here a little bit more, we can see the sign that he was looking at is sitting right here, where it says the no loitering, no soliciting, and all that stuff for the bridge that you go across. Completely open to the public to go on and across. And we look at the other side, and this is a public street right here. This is public street, public sidewalk. Nothing that restricts, so it would be pretty much like the common courtyard issue, which is one of the things with the GSA stuff. And maybe Merbeast might be able to maybe give us a little bit more elaboration on this. I want to hear his opinion on this at some point. And you can see the exact same signage is posted right here. And is my mouse even showing on this? Well, okay, no, my mouse isn't showing. So let me. Oh no, it is. Okay. So it should be showing. What happened here? Window capture properties. Something happened. Oh, I know what happened. Let's see here. Chrome, Google Maps. There we go. Fix that. Okay. But back to looking at this. As you can see, that sign is there right at the entry. But as is, this is all open to the public right here. This is a public crosswalk that leads right up to it, goes on to it, and pretty much becomes a public crossway to get over to it. So in my opinion, personal opinion, this would be public access. People would be able to film from it. It would fall within at least the public forum idea that Merbeast usually touts. I would, as I said, I would like to hear his opinion. Otherwise, you're forced to go on Camino de la Plaza and take that all the way up to here and then come down, because this is all public sidewalk on at least that side of that street there. But yes, this is quite the interesting thing. And let us take a quick look at this is Solus Productions video of what happened that day from the bridge there.
Move! Move! I want to walk. You're blocking me. You're obstructing, sir.
I need you to walk
You're
that way or
obstructing.
that way.
I like to move that way, but you're in my way.
We're not doing nothing. Hey.
Okay, see, I'm walking. Oh wait, you know, actually, I gotta go this way. Actually, I'm sorry, I gotta. See, you're blocking me. What's your problem, sir? What's your? All right, thank you. I don't feel.
Yeah, what we get. Yeah, walk of shame. Walk of shame.
Yeah, if you notice, they freaked out about the filming here.
That's all we're doing. Just filming.
Good thing they didn't delete the videos.
Just filming. That's it. What's wrong with filming? What's wrong?
Let me
What's wrong
stop
with
that.
that?
We're just filming.
Yeah,
That's all.
look at all these guys, man. This for some cameras.
Now we're just filming. I don't know why all you guys are showing up like this.
Keep it moving.
Leave the property right now.
No. Keep it moving. Look at this. Look at this. Look at this, guys. Look at this, guys. Look at all these guys up here, man. The cameras, man. The cameras. The cameras, guys. Look at all this. We're at the U.S. Border Custom in California. How do you say it, Chris, bro? We're over here at the border.
Pardon me.
Now, this is my recommendation. Or for those that were all at this Border Patrol incident several months ago, they should get a hold of the attorney that is pushing this case. Maybe they can get in, because when what happened was this was dismissed at the district courts. The main reason that it went to appeals is because they appealed the decision of dismissal. So this is going to go back to the district courts, and it might be early enough still in the case where they could probably get added in on this. They might have to fork over some bucks, but I would say they fit in with this filing, and they could probably get added into it. And let us listen to, where is it? I know I have it on here. I was listening to it earlier. You know what? Hold on. Give me a second, guys. I got to pull it up from over here. Because I thought I copy-pasted it, but I guess I didn't. But this is the oral arguments from the Ninth Circuit.
Of the challenged policy.
And the way they open it up is going to be interesting. We're going to listen to a little bit of what's happening, what the attorney for Askins' attorney states, and this is very interesting.
Yes. Good morning, Your Honors, and may it please the Court. I'd like to reserve 3 minutes of my time for rebuttal. This case is a constitutional challenge to U.S. Customs and Border Protection's policy of
Hold on, guys. I'm going to turn this up.
without advance permission all photography from any area that the agency unilaterally declares to be port of entry property. Plaintiffs are 2 U.S. citizens who have alleged...
a little more into the microphone?
Of course, Your Honor. Is this better?
Yes.
Yes. Plaintiffs are 2 U.S. citizens who have alleged that they attempted to engage in protected speech by taking photographs while standing outside in traditional public forums near 2 different ports of entry in Southern California.
Okay. What have you alleged about whether they were on CPB property?
Your Honor, that's the core factual question that remains undecided in this case. It is our position that the clients were not on property that's correctly conceived of as port of entry property. But the government has applied its challenged policies to them. So the government does believe that they were standing on port of entry property.
So you think that you were on CBP property, or that you were not on CBP property?
So it may help.
And let me tell you that I think that your answer may be nuanced about what kind of forum
Yes, Your Honor.
we should apply, but the question of who owns the property seems to me to be a good starting point.
For sure. We just don't know at this juncture, and maybe it will.
This is Askins v. United States Department of Homeland Security. I will have the postings in the text, text a little bit later. You can look up the case number is 16-55719. So if you want to go and pull it up, I think Spy Team Satan posted a link to the case decision. You can easily look it up on the should be showing up. Yeah, it's showing up. Right now, you can look it up. The watch code is 0FMG, capital G, SI2QQ6I, I think it is.
Will help if I explain, for instance, where Mr. Askins was standing. So,
Can I ask a preliminary question?
yes, Your Honor.
At the port of entry properties, does the government own the property, or is it a designated area that they control, but it's not public, federal public land? Which one is it?
I do not have a clear understanding of that on these facts. It's my understanding, based on representations of counsel in the briefs, that these buildings are leased from GSA by the agency. But the areas around the buildings, the outdoor areas that are at issue in this case, it's unclear whether they're owned by the government, the federal government, or local property. And to answer Judge Bybee's question, so Mr. Askins was standing across the road in Calexico in the United States. Right next to where he was standing, there was a public park, a state park, I believe. It's a
And it's
friendship park.
described as being a street, an intersection of a public street. What does that mean? It means people just walk around the street?
Yes, Your Honor. There's a storefront, so there's a strip of pavement, there's a small curb, and there's another strip of pavement. Those are streets that cars can drive on. There's also a sidewalk that curves around a green area that's a park. And he was standing just off the sidewalk in the street.
And the people who are driving on this road, are they having anything to do with the border, or they're just
Not
driving?
necessarily. The road in question runs east to west, entirely on the United States side of the line.
Is there anything that would indicate that you were standing on CBP property?
No, Your Honor, and that's part of the problem here. As this court's precedents have said over and over again, the expectation that one has a First Amendment right to engage in speech in traditional public forums in areas that are publicly accessible, for speech to be restricted in those areas, that expectation, the government has to take clear steps to make clear to people that they can no longer engage in that kind of activity. That's what Venetian Casino said. And here, there's nothing that would indicate to a person who has not had to cross any border or interact at all with the federal government, in Calexico, for example, that he or she is on port property while trying to take a photograph. I recognize...
Governments, well, several things. This was all done in a motion to dismiss.
That is correct, Your Honor.
Government is claiming a security interest, essentially.
Yes, Your Honor, although the only interest that the district court assessed, and only in dismissing our original, not the amended complaint, was an interest in territorial sovereignty, which was not an interest that the government actually put forward in any of its briefs.
But also you represent, I don't know exactly what the complaint says, that it isn't even clear this is federal territory in an ownership sense.
Yes, Your Honor.
What does the complaint say about that?
The complaint says that the areas where our clients stood and to which they would like to continue, in which they would like to continue to engage in their protected speech, are considered by the defendants to be port property, such that the defendants have applied the challenged policies to our clients.
But there's no allegation as to ownership as such.
That's correct. We just don't know at this juncture. And ownership isn't dispositive.
Yeah, and that's the big issue, ownership of those areas. And I have spent quite a bit of time also trying to look up property detailed information around the area, which is not an easy thing to do when trying to look that stuff up. I've been trying to pull up property information from the San Diego, it was the county assessor's webpage, which is not an easy thing to do because you have to have the exact information of all that stuff. Now, this is one of the tax maps I was able to pull up. This is for specifically a storefront location right here at the rail courtyard next to the other San Yarado, I know I'm butchering it. Little boulevard and cul-de-sac there. And as you can see, whoops, wrong one. This one here. As you can see, this is definitely like public roadway, street, highway there. This is where that property is at. This is not exact. These property lines are not exact detail. And also you can tell, since it's like mostly handwritten, it's very confusing and not straightforward with all the meanings and all that stuff. But you can see this is definitely some sort of roadway here. Well, this is the rail transit, and then here's your sort of cul-de-sac, and then this is right around here would be the start of the pedestrian bridge that goes across. And so this will also be in there. I haven't been able to really pull up defining property lines for the eastern side here, but when you go and look at roughly right about here, I think it is, give me a second, which will be an interesting thing. You can see one of those defining demarcation lines stating this is U.S. government property past this line. And then when you zoom up over to here, you'll see this sign says this street and sidewalk are property of U.S. government, authorized individuals / vehicles only. All others will be cited and towed. So only specific vehicles are allowed to go down this street. And as you can see, this is all paved. This is a parking lot right here. And you can tell this is on the south side of that barrier. Now, where this fence is at, does that mark the end of the property? I don't really know, and would require much further investigating for all of this, obviously. But what I also sort of find interesting here, let's do a quick zoom out, and we're going to zoom back in right over here. And we'll twist this around. If I remember correctly, I think this is a brand new like border crossing that's been installed in the last 2 years. It looks like there's sort of a storefront here also. Or at least some sort of storefront rentage. As you can sort of see, there is like a little strip mall here with like that's a commercial sign, and that looks like commercial signage right there. So what is going on here? I don't really know. It seems like there's a lot of gray areas for this entire situation. Is this state park? Is this federal park? Or no one really knows at this point. I would probably have to go in and like literally talk with the tax assessor to get a property map for this specific spot to say, okay, who owns that spot? And the GSI maps are not helping in that regard either. They don't give any detailed information around this specific area. It's just all marked as like sort of public area kind of thing, or public access. So let us skip ahead though to when the government attorney gets up there, and this is going to get quite interesting.
Under surveillance. So
Good morning, and may it please the court, Thomas Pullum for the appellees. The plaintiffs here ask the court to hold that the First Amendment guarantees an unfettered right to photograph sensitive government operations and highly restricted government facilities.
Not unfettered, unlicensed. I mean, they didn't. I mean, the case can go in several directions once it goes on, but they're contesting the fact that the government is saying they can't take photos at all unless they get permission with no standards for the permission.
What they're asking for is an unfettered right to photograph, that they shouldn't need any kind of, that they just are allowed to walk on.
Doesn't this depend on where we're standing? I mean, there may be a difference between where Mr. Ramirez was standing, where Mr. Askins was standing. But if we start with Askins, the government's got a tough burden here to show that they've got an interest in a guy standing in the middle of a public street taking a picture of a building.
So I think it's important to look at what is in the complaint as opposed to some of the representations that counsel has made here.
Well,
and some
all
of the
kinds of stuff. I mean, this was dismissed by the district court without getting without anybody even being able to submit a map.
So there is no allegation in the complaint that there was any confusion as to whether Mr. Askins was on.
I mean, it's
on the
not
port of entry
really
at the
in
time.
some ways worth the energy because what she told us could be added to the complaint, right? In other words, she could amend the complaint. So if the problem is there's something not in the complaint.
I'm sorry, Your Honor.
What?
The plaintiffs have amended it once.
Right.
And they have still failed to make some of these allegations.
What have they failed to state?
Well, I don't think there's any allegation in the complaint that there was uncertainty that this property was part of the port of entry. Now, to be sure, they assert that it is a public forum, but I don't think there's anything there that says, this was not
essentially, we don't really know what public forum. We understand that you're claiming this property is public forum. That's what they said. They said, and as I understand it, but they didn't say because they don't know exactly what that means. Does it mean the government owns the land, or what does it mean? But they do say specifically that the government is claiming this is. We understand they're claiming this is public forum, and this is port of entry.
The port of entry, yes, and they do specifically allege that in the San Ysidro areas that there are signs that quote appear to prohibit any form of photography from those outdoor areas.
And so in my hypothetical, for example, if somebody is at this transit plaza and taking a tram from somewhere in San Diego to somewhere else in San Diego and wants to take a photograph of their friend, they can't do it.
If they're on part of the...
D.A. Archer, this is from the Ninth Circuit Court of Appeals YouTube page. Yes, they have a YouTube channel. You can watch these, and I'll have a link in the description later on when I get done with this video. If you look in the upper left-hand corner, you'll see the Ray Askins v. USDHS. Type that in specifically in the YouTube. You should be able to get it the pop-up fairly quickly within the first couple of results. And Godbrother, yes, I usually have in the night with some drinking and, recovering from drinking and eating a pizza. That's going to have to wait till next week because this beginning of next week, I have my next court case. Talking about forums, yes, and this is actually going to be a very interesting thing. As I said, this is actually something that would probably be right up Murby's alley because he talks quite a bit about the forums.
The port of entry, yes. And
this transit plaza, as I understand it, it's claimed to be in the port of entry. Even though people are taking trams from one place in San Diego to another place in San Diego.
I mean, it's a little unclear exactly what we're referring to in the complaint here. All that we know is that the plaintiffs have said in or near these areas there are signs. If we found out,
I mean, wouldn't it make more sense to let this case go to summary judgment and find out what we're talking about?
Well, I think this case,
because
for a couple of reasons,
it could really matter. I mean, if my representation seems consistent with the complaint, and if it's true, then you have a situation where the government is trying to stop people from photographing on property that, whatever its official status is functioning as a part of the city of San Diego for people who have nothing to do with the border.
The same thing was true in the Supreme Court's decision in Greer v. Spock. There we had public roads that traversed the military base.
Yeah, but there, this was a military base. You knew you were entering a military base. You knew you'd been granted access for limited purposes.
Well, the public had unrestricted access to those areas of the base where they...
Sure. It's like going to Fort Knox and going to the Patton Museum.
Go through a fence, right?
There were gates, but they weren't...
Right, but there are no gates here, no gates.
Do you have signs?
Well, we know that there are signs in at least some areas because
The signs don't really say much. That's the thing. Your signs are of GSA policy, which also has been outlined in the 2010 and now the redone 2018 DHS memo, which applies to these specific situations and only apply for the interior really of the building, not really the outside areas, which is the big issue. And the DHS memo from Mishmeshi versus the Department of Homeland Security, I think it was, or that was over in California, not California, over in New York, dealt with a guy that was taking pictures and filming from a public plaza area on federal property where he was legally allowed to be at.
Plaintiffs have alleged that. They haven't made any allegations.
Shouldn't we figure out whether we've got a sign that telling you when you've entered the port of entry and where the line of demarcation is? There are no.
And that judge, bam, one hell of a good question. Shouldn't there be proper lines of demarcation?
There are no signs where Mr. Askins was. Are there any signs that tell you that you can't take photographs there?
There are no allegations in the complaint that there are not signs there. He says he was standing near the shoulder of a road. And I think it's important to look at kind of why he was there.
The defendant is the U.S. Department of Homeland Security and their sub-agency, Customs Border Patrol.
Well,
on their own
at least alleged, Askins has at least alleged that this was a public forum. So even if it sort of implicitly concedes ownership by the government, it still suggests that it's just a public street, even if it's owned by the Port of Entry or GSA or whoever.
They have made that kind of legal assertion that, yes, it is a public forum.
And do we have enough facts to be able to decide that question here?
Well, I don't think we have enough allegations that, if proven,
well, if they've alleged that it's a public forum because it was a public street.
But they haven't alleged...
what else would they have to allege?
I think that it's not part of this port of entry, which has a kind of clear purpose to facilitate the lawful transportation of goods.
Well, in part, but it also is doing a whole bunch of other things, apparently. People are going from here to there, having nothing to do with the port of entry.
But the fact that the government permits some portion of the port of entry to be used for other purposes...
You haven't got a gate there, or you haven't got a green stripe that runs down and says, now entering the port of entry, warning, some restrictions may apply. That would have told him if he'd stood 10 feet back on the grass that it would have been okay to take the pictures, but he couldn't do it where he was doing it.
So we just don't know because the plaintiffs haven't alleged that.
Why don't we figure this out rather than jumping to the conclusion that the case can't be decided? They've alleged that it was a public area. I think Ramirez is a little bit more complicated. But with Askins, they've at least alleged that it's a public forum.
So what they came to do here was take photographs of, and Mr. Askins went to the area for this purpose, to take photographs of the secondary inspection process of that area, which is one of the most sensitive areas of the facility.
And if he was standing 2 feet back on the park property, he could do that.
Yes, but it's not clear that he could see exactly the same thing from there, that the angle would be exactly the same. The district court...
We don't know that, do we?
Why don't we figure this out?
Well, I mean, he...
As you can see, the judges are just like, why aren't we figuring this out? Why do you not have the answers to these questions for, something that should be known before dismissals pretty much happen? And that's what this lawyer is trying to do. He's trying to prevent this from going back to court. And what happened with the Supreme Court is, not Supreme Court, with the appeals court of the Ninth Circuit, they sat there and said, this needs to go back to district court. This needs to be tried. The grounds of why this was thrown out is not valid, and it needs to actually go to court. That's what Askins is pushing for. And the thing is this was just recent. This was argued in February. The decision on this came out in the last few months. And on top of that, well, actually this month, and on top of that, they filed this back in 2012. This shows you how long these court cases can last. And these people are just trying to get a decision to enforce their rights. Imagine how much money they might be out trying to push this. This is not a cheap case.
Could have made that allegation in the complaint. All that the complaint says is that the exterior of a building was visible from the park, not that the specific part of the secondary inspection area was visible. And several courts, including the Supreme Court, have repeatedly rejected the argument that the First Amendment it contains a right to go onto a government facility and take photographs of operations.
I mean, the problem here is the government has been arguing from cases that do seem inapposite. His presentation here is that he's not seeking access to any place that he doesn't have access to. He has access. Everybody has access to this spot.
Well, some amount.
In that middle judge, she made one hell of an argument right there. He's not seeking to gain access to any more than what he's able to already access as a general public person and to be able to film from those locations. These areas are open to the public to wander through without any big issue, but yet filming seems to be a big issue. And D. Asher, I'm glad to hear that. I'm glad that I managed to train at least the Anchorage Airport quite well on that issue. But just keep in mind, I did uncover a specific law in Alaska that sort of deals with it. It looks like it's not being enforced. It could still come back and bite people in the butt. So I just want to advise everybody, Alaska does have a law on the books, a statute that says it's not legally valid to film or photograph or record the security checkpoints at an airport, but it hasn't been enforced, and I think they might know it's going to be. It would fail in the larger court battles and all that stuff. That's something we're just going to have to keep a close eye on, to be honest. But let's go ahead and get back to this.
Why are we relying on access cases?
So I'd like to say two things. One is that there isn't just an unrestricted right of physical presence on this area. CBP can close the facility as required for the...
But at the point he was doing it at hand.
So
there was,
and
but
loitering...
at that point there was access to anybody who wanted to be there, when he was there.
Yes, under several restrictions.
Why is it an access question?
You can't... Well, so this court said in Lee v. Salazar, when confronted with a claim that someone had the right to view a horse roundup, that this isn't really a forum case because what is sought is information. It's not seeking a kind of dialogue that would implicate forum analysis. So to here, what the plaintiffs seek is just information about how these government operations work.
No, they're not seeking the information. As I understand it, they're saying we can stand here and we can gather the information in our heads. No one's stopping us from doing that. What you're stopping us from doing is recording what we can see. So it's not a question of information. It's a question of essentially creating a communication for other people. And there's myriad of cases saying that in the context of watching the police or watching government officials, if you could otherwise be there and watch them, you can take pictures of them.
So two things, if I may. One, with respect to locations where people have a constitutionally guaranteed right of access, they do not have a constitutionally guaranteed right to take photographs, such as this very courtroom and others that we have, other facilities, town meetings.
But that's why the forum analysis could matter here, right? What is this place exactly?
No, I think the point is that these... even when you have a right to be someplace, there is not necessarily a First Amendment, or not at all, a First Amendment right to take pictures.
The case the other day, Jacobson.
Could I make one more point about, I'm sorry, with respect to the filming police in public places that Your Honor referred to, those cases have all acknowledged that that right is subject to reasonable restrictions. The First Circuit specifically referred to restrictions that could be
But the restriction here is you can do it if we let you, and you can't if we don't. That's the restriction.
Yes, the restriction is that it has to be...
Is that a reasonable restriction by First Amendment? Under the First Amendment case law, there's a great deal of discomfort with that kind of totally discretionary decision-making about First Amendment rights.
I think when we're...
And she's got one hell of a point there about the whole... there's a lot of contention over just being able to deny or allow people to be able to document these things that's going on. And there's going to be something else interesting. We're going to go back to the case law reading, and I'm going to read in the decision that came out that is going to perk up a lot of people's ears, because there's some arguments that we use, legal arguments, and why this is one we need to keep an eye on. This Askins case is a case that we really need to pay attention to.
We're talking about a government facility where sensitive, some national security operations are happening, that it is entirely reasonable that the government would take action to prevent the dissemination of information about its most sensitive operations there, and that otherwise...
For example, they said you can't take a picture of the secondary facility, then we could have a discussion about that, but that's not the rule.
No, the rule says that things will be prohibited where they interfere with the mission of the agency, and then several criteria are set out.
They'll be prohibited unless we say you can do it.
Well, there are several criteria that guide that, and the Supreme Court has indicated, and so has this court through its policy regarding recording.
Can you show me where the criteria are?
Yes.
The media guidelines?
So in the CBP media policy on 91, it says the CBP shall cooperate without favoritism while not compromising the mission. And then a couple sentences later, responses shall be tempered by concerns for ongoing investigations, sensitive foreign activities, operational factors, detection, targeting, and selectivity factors, techniques and capabilities, exchange of intelligence, and matters in litigation.
Right, and this is advice, internal advice to how to make the decision, but it's not
right.
a standard that somebody can come in and a company come in and say you didn't comply with the standard because you weren't tempered by a concern for ongoing investigations.
No, that's correct. But in this type of, when we're dealing with a kind of highly regulated government facility, selective access and a level of discretion are, I think,
How highly
appropriate.
regulated can it be when people are allowed to walk all around, walk from the park and cross the street?
Bam! Ooh! That... How highly regulated can it be when people can just meander onto the area? That is a good and excellent question by that judge. That is one hell of a bombshell drop, because it's regulated, all this and all that, and then well, how regulated can it be when the general public can just walk through there? That is a good question.
So there are several restrictions. There is no loitering. Bags are subject to search at any.
I did not see a sign for when you were going across that pedestrian walkway that your bags would be subject to search if you go across this walkway. I see a no loitering. In fact, let's go back. Okay, let's go back over to California Guardians here. When he looks at these signs, let us double check that here.
California Guardian, I'm over here with
Pedestrian bridge.
Dave, just Dave.
No loitering or soliciting bicycles and motorcycles are prohibited. Your conversations and actions are being recorded.
We're on this bridge, which was used. We're
and then the standard GSA little warning signs. Now, maybe we should probably double check and see, maybe in the fine print it says we can be searched when we're trying to go across.
the guys.
But let's skip ahead a little bit because we already covered this part. And let's look at that other sign over here. Please walk all methods of transportation on the bridge. No skateboarding, bicycle riding, rollerblading, or scooter riding. And then it repeats it in English. And no a smoking sign there. So, you guys get an idea. That I don't see a sign that says you will be subject to search when you cross this bridge. And I sure as hell didn't see one over in this other area. Let's go ahead and do a quick Google Street View here. Over in this other area, which I suspect actually was where the other guy got held up for standing, probably over by this public crosswalk. As I turn this around here, he was probably standing somewhere in this area over here to over here. And the names of the streets probably have changed between that time frame, because I suspect it was somewhere in this area where he got hemmed up. And I don't see anything about your baggage is going to be subject to search by walking in this general area. Yeah, quite interesting here. And let's go ahead and listen back in on this.
Anytime. When we think of other places where those types of policies apply, airports, for example, courtrooms, other government buildings.
Okay, he's going to get smacked down on this one hard. I listened to this before. And the thing is he's making airports. Well, guess what? They have a restricted side that you have to go on to. I mean, get past to get to your gate and all that stuff. Well, guess what? That implies going inside a building in most situations. Courtrooms. Once again, that's a controlled area inside a building. This guy and the other guy were standing out in public, outside of buildings, on public walkways or transportation ways or pathways.
Those are not public fora that are dedicated to free expression. There are other restrictions on leafleting, on solicitation.
And guess what? Multiple times in the courts, all the way up to the Supreme Court, even leafleting. You can stand outside the Supreme Court on the sidewalk and leaflet. You are legally allowed to do that. There is a Supreme Court case decided in the last 5 years on that specific issue. I looked it up. I read it. It was quite interesting, actually. He couldn't stand on the side. I think the issue was the guy might have been standing on the stairwell or something like that. But they said you can stand on the sidewalk, but not on the stairs that lead up to the courthouse and all that stuff. But yeah, guess what? These guys were not standing inside. I mean, they were on the public walkways.
So there are actually quite a number of
All right, so let's go to
restrictions
Jacobson, which
yes, please.
seemed to be a somewhat similar situation, and where there was a protest that was at issue, and the question was, we need to know a lot more about this place before we know whether it's functioning essentially
Yes,
as
so
a
I think
non-public forum or public forum.
I think Jacobson is distinguishable on several grounds. One is
Let me just say something in general.
yes, ma'am.
You can distinguish anything. The question is, are its principles applicable here?
Well, I think that the applicable principles are different for several reasons. One is the claim in Jacobson was not just seeking photography. There were issues of kind of physical access, and specifically, the plaintiffs there were seeking to engage in a protest, which has elements of
Ordinarily more disruptive, and you'd have more control over it.
Well, so as this
if they want to have a protest in the spot that we're talking about, would you say, oh, fine?
No, they certainly could not have a protest. But the point I was trying to make was that this court in Levy-Salazar said that when we're dealing with types of expressive activity that are more like a dialogue, then we have a different type of analysis, the traditional forum analysis. In Levy-Salazar, it said this is more about gaining information about a government operation, so we look at the right of access cases. And the right of access doesn't involve a right to photograph. Other differences from Jacobson, we had different allegations, one about inconsistent application of the policy.
Well, as I understand Lee versus Salazar, was the rule that anybody could come here and look at this horse roundup?
No, I think that was part of what
it was an access question, because the government rule there was you can't come here.
That's correct.
But that's not the rule here.
No, but even when there is...
How's this an access question?
I think for the same...
How is this an access question? The government said they couldn't watch the horse roundup because the general public wasn't allowed in that area. But in this situation, the judge makes a point. People are allowed to wander in and out of this area at will. So it's how is the access question the exact same for both of these when he's trying to reference this horse roundup case, which I haven't read, so I have no idea. I've been busy researching other parts. But I figure this what I got and what I'm disseminating to you guys is more than enough to give you a good idea of why we need to keep an eye on this case. And the arguments here are just insane what the government attorney is trying to bring up. And hey, Nasty Nathaniel, nice to see you popping in here too.
Reason that other cases, including ones we've cited in our brief, where people
Is there
have...
any case in which somebody was someplace they were allowed to be, and the public in general was allowed to be, but there was a restriction on photography and they called that an access problem?
Yes, several courtroom cases. I believe Rice v. Kemper in the Eighth Circuit. There's the Third Circuit case.
Wait, this is prohibiting photography in the courtroom?
In execution chamber.
Well, you don't have a right to be in the execution chamber.
My goodness, that sure seems far afield from somebody standing right near a park on a public street.
Ooh, burn! Yeah, okay, the Third Circuit, I remember that one about the execution chamber part. Yeah, the general public doesn't have access. It's a far cry from being on a public park. An execution chamber is not open to the public. The public park, that's open to the public. Public walkway, people are to walk. It's open to the public. No way these two things are close to similar. Where the hell, as is, I think they're literally trying to grab as much shit as they can that closely matches and just throwing it at the wall and trying to see what can happen. I mean, what will stick. And it doesn't look like it's sticking for keeping this case going back to trial. So let's go ahead and come back in.
Well, I mean, there are several courtroom cases that have involved different types of analysis that all get to the same place, where you have a First Amendment right to be present, but no First Amendment right to photograph.
Right,
And we listed...
A courtroom would be very different from a public street, and they have alleged that this is a public forum.
Well, it's
so even if that concedes ownership, and I think ownership, at least for me, ownership is still very much in question. It doesn't tell us what the government wants to do. I mean, Washington, D.C. is a federal enclave, but you get to walk up and down the streets and take photos of government buildings.
Oh, ouch, bird. I love this guy on the left there. Washington, D.C. is a federal enclave, but you can still walk up and down the streets and take pictures of buildings. That is a really good thing. These things are something we got to keep in mind
all the time.
Yes, from places that are not kind of, and so one reason why this is a little different that the plaintiffs have pointed to is that some of this happens in outdoor spaces. But by necessity, these government operations happen in outdoor spaces.
It's fine, counsel. I mean, you've got Greer versus Spock running completely in your favor. If you had fenced this off and said, you consent to the terms, this is now restricted area, drive through, come and park, go to McDonald's, go to Jack in the Box, shop within this area, but we want you to know it's a restricted and controlled area and certain restrictions apply. We'd be talking about a very different case.
So this court's case in...
Oh, bird. Yeah, the thing is there's no gate. All they got is two signs on either side of that walkway. And then Askins wasn't even on that walkway. He was at an intersection of two streets that was able to view at that time frame what was going on from that position.
Decision in Hale involved a nuclear test site, and the road that where access was sought there.
But they're not seeking access. That's why you keep coming back to that. They have access. They're there.
Yeah, they have access. The point. That's what the judges are pointing at. Is like the lawyer is going on. He's trying to seek access. No, they already have access. This is open to the public. If you want to have the access argument, you have to close it down or have some sort of indication that this may be open to the public, but you are open to the public with these restrictions that are in place in big, bold writing pretty much at that point. It's got to be obvious. It's very similar when, like, you go, the Edwards Air Force Base, where after you pass a certain point, oh, there's a sign. The sign's changed. This is now military property up and all the way up to the gate.
They have some limited right of
access. This is the test site in Nevada?
Yes. There was no gate there. There was a cattle guard. And on one side of the cattle guard was the facility, and on the other side was not. The court didn't point to any kind of signs or manned gate or anything else. And so I don't think that is necessary. In Greer, there was a gate, but it wasn't manned, and there weren't signs limiting activities. The Supreme Court looked at the purpose of the facility and whether the government had abandoned the right to regulate activities there, and the court said clearly it hadn't. So too here, CBP has not abandoned the right to restrict activities on the
What were the people trying to do in that case?
In which case, I'm sorry?
Hale.
In Hale,
This is a peace protest, right?
I believe yes.
Yeah, and were they blocking the road?
No. I don't think there was anything about the blocking.
How far off of the main highway were they trying to go?
So I apologize, I don't know all of those details, but my understanding is that there was a road connecting the kind of main highway that led up to the main part of the facility, and there was a special parking and demonstration area. And the agency there had said, Department of Energy, I suppose, had said that demonstrations were limited to this demonstration area, and the plaintiffs there did not want to be limited.
but you actually had an area there that was designated for protests. They simply wanted to go someplace
else.
Well,
approval was required.
Right. But this is the Nevada test site. I mean,
Now, one thing I sort of want to point out, which is interesting, is this lawyer, the government lawyer, was allowed to speak way longer than the Askins, Ray Askins attorney here. We're 34 minutes in, and let's take a quick look at our little thumbnail thing here. Roughly at the 14-minute mark, she reserved her time for like the last 5 minutes kind of thing. And we're at 34 minutes. Pretty much you get 20 minutes to do your arguments when you're doing this. And we have already surpassed 20 minutes, and this goes on for nearly another 3 or 4 minutes.
I mean, it's pretty obvious where everybody was at that point. You're talking about a road that divides Calexico from the public port of entry that's not marked at all.
Well, I guess we don't know whether it was marked or not.
Shouldn't we figure that out, counsel?
Look at that smile. Shouldn't we figure that out? Exactly. This is why it needs to go to court, pretty much. He's making it pretty obvious. This needs to go to trial. The facts need to be found on these two incidences, and the boundaries need to be decided. That's what's very important about it.
Just tell me that we don't know that. I agree with you. We don't know that. Shouldn't we figure that out?
Well, so at a minimum, we know for the areas in San Ysidro, because the plaintiffs included in their complaint that the government had posted several signs saying that photography was prohibited. So we don't need to know, at the very least.
So you just think we should dismiss the complaint with respect to Ramirez, but it's okay if we go back on Askins?
Well, we have asked the court to affirm the district court's judgment. However, if the court were going to remand to find out more information about signage, then I think...
I mean, find out more information means litigation proceeds as normal, i.e. you file an answer, and then you file for summary judgment motion, and you provide some of these answers, and then if they have other answers, they provide other answers, and then we know what we're operating on.
We get a map of the area. We get photographs. We get Google View. We get anything.
Hey, Google View! What I just used to do all this research for most of the evening. Now, I've been looking at since like 8 o'clock this evening. Well, 8 o'clock last night.
That's available to us. We get to file the plats. Something. That tells us what's what.
That is true. That would happen on a...
Sure feels like if we had that information that both sides here would be able to make a much more refined argument.
I think that's true, but
or put another way, there is some set of facts consistent with the complaint that would seem to say this is a public forum and you do have a problem. I.e., it's a public street, anybody can walk on it, and it appeared to be, photography is generally protected by the First Amendment, and so on. Then you may have other facts, i.e., it really, for various reasons, it isn't really like a public street, and it isn't really a public forum, and so on, and that's what we can't judge right now.
Well, I think the question is whether
And that's essentially what Jacobson did. You never really finished with Jacobson, but the main message of Jacobson, isn't it, that you, in order to decide, that it isn't per se the case that around the border people have no First Amendment rights. That's one message, because if it was per se the case, they wouldn't have to know anything else. And number two, that beyond that, you have to know the details to decide what people's rights are and where. That seems to me to be the two basic messages of Jacobson, whatever the details may be.
Well, I think what Jacobson did not do is overrule this court's precedent in which cases involving First Amendment claims and forum analysis have been decided on a motion to dismiss.
In very different places. I mean, one of the beauties about property law is that all property is considered to be unique.
Well,
so what applies at the Nevada test site may not work at San Ysidro. What works at San Ysidro may not be the same at Calexico.
True, but one of the cases that we cited in our 28J letter, this Santa Monica nativity scenes case, involved
an excellent opinion.
It was a very fine opinion.
I wrote that, and when I looked at that, it sounded as if the complaint included extensive exhibits from the government, and that formed a record upon which my colleague here, Judge Bybee, could rely on in the panel in deciding the case on a motion to dismiss.
Yes, Your Honor, and here the complaint also included as attachments the policies that are challenged, which on their face indicate the government interests. And as in Santa Monica, the complaint alleges no facts that would, if proven, demonstrate that these interests are not served by...
I guess the main fact was that he had a right to stand exactly where he was and see exactly what he saw.
Well, not an unfettered right. I mean, there's a regulation that prohibits loitering on these areas. And again, the plaintiffs have not...
There's loitering statutes all over the place. They're not necessarily valid, but every city has one, or had one.
But I don't think they're...
And that is true. And the thing is loitering statutes are limited to literally hanging around and not having any purpose in most situations. And the thing is if you're standing there filming, you're not loitering. You're filming. You're actually conducting an activity. And so the loitering aspects is easy to argue when it comes to exercising civil rights. Okay, I'm standing here leafleting. That's an action. I'm not there without a purpose. I'm there with a purpose. I'm standing there with a camera, filming or taking pictures. I'm standing there and doing something with a purpose in that position. And as the center judge there said, there's several, every municipality and everybody has had a loitering statute at some point or ordinance. And the thing is not all of them are valid. Many loitering laws have been found invalid because they've been too broad.
Again, I don't think the plaintiffs have alleged that they were not actually on the port of entry. They're just saying that part of the port of entry is a public forum. And even if the court were a little unsure about...
Public street.
I'm sorry?
Because it functions as a public street.
Yes.
Okay, your time is way up. Thank you very much.
Okay. Now, I'll have a link in the description for this later on. You guys can check out at least for what happened with the Askins attorney and all their responses for all this stuff and their case. I really hope there'll be a chance that we'll hear more about this case after while it's going through the district case. If anybody's got parts, I would definitely keep an eye on this part. But literally, and this is not a prosecutor. No, this is a defense attorney for the United States government. I can't remember who was it. I think it was you were saying that the prosecutor, he's not a prosecutor. He's a defense attorney for the United States government. Now, let us go ahead and go back to the reading here of the case. And I want to point out something. And if I remember correctly, it was page 17. So we're going to scroll down to page 17. 11... let's see here. Is this getting close? Okay, 14, 15. Yes. Plaintiff's First Amendment claims, B, on page 16. Sorry, not 17, it's 16. Hoping the three judges were giving the guy his rope to hang himself on to prevent from to prevent coming back. Yeah, well, the thing is, it needs to go before the district court, and this was dealing with the appeal of the dismissal of the case. Now, when this goes back to the district court, what's going to happen is the two lawyers are going to fight it out through a bunch of paperwork. One's going to file some claims, the other one's going to retort, and that'll go back and forth for several months until the judge says, okay, let's look at I got a decision, we're going to decide on this and all that stuff, summary judgment, all that. But let's go ahead and read this part. In their amended complaint, plaintiffs claim that CBP's policies impose unconstitutional restrictions on their First Amendment right to photograph and record CBP officers engaging in public discharge of their official duties. They contend that policies impose a prior restraint and prevent the documentation of civil and human rights abuses, including the excessive use of force and racial or religious profiling at the border. They do not seek unrestricted access to all areas of port of entry or unlimited photography privileges, but rather assert their right to photograph only those matters that are exposed to public view from exterior or outdoor areas of the Calexico and San Ysidro ports of entry. Plaintiffs have alleged that these areas, even if leased or owned by CBP, are public streets and sidewalks that must be considered public fora, or forum, or foray. The First Amendment protects the right to photograph and record matters of public interest. See Animal Defense Legal Defense Fund versus Washington, 9th Circuit, 2018. I'm actually going to have to look that one up because that looks like something to be like. Freudis v. Seattle, 1995, 9th Circuit, a case that I actively use over here to cite for why I'm legally allowed to film in public. Anderson v. City of Harmoroso Beach, 9th Circuit, 2010, holding that the process of creating pure speech is entitled to the same First Amendment protection as the product of that process. This includes the right to record law enforcement officers engaging in the exercise of their official duties in public places, referencing Fortis that we just cited. Glick v. Cunnife out of the First Circuit, 2011. Recognizing that the First Amendment protects the filming of government officials in public spaces. Smith v. City of Cumming, 11th Circuit, 2000. The First Amendment protects the right to gather information about what public officials do on public property, and specifically the right to record matters of public interest. These are cases right here that we often, Glick v. Cunnife, Smith v. Cumming, and of course, obviously, Fortis v. the City Seattle. 3 cases that we use. This is right up our alley, and why we need to pay attention to these legal fights, because when they come by, we can glean more information and knowledge from these and better prepare ourselves for in case we gotta go in front of the courts and fight ourselves. And in fact, I'm probably going to end up having to use a few of these arguments with Springfield myself, I'm betting, in the future. Let's go ahead and continue. Whether a place is public depends on the nature of the location. The government's ability to regulate speech in traditional public forum, such as street, sidewalk, or park, is sharply circumscribed. In the Perry Education Assistance v. Perry Local Educators, 1983. Content-based restrictions on speech are subject to strict scrutiny and may only be upheld if they are at least restrictive means available to further compelling government interests. Berger v. Seattle, 9th Circuit, 2009. Reasonable content neutral time, place, or manner restrictions, on the other hand, are subject to an intermediary level of scrutiny. Jacobs v. the U.S. Department of Homeland Security, 9th Circuit, 2018, quoting, International Social for Christian Consciousness of California versus City of L.A., 9th Circuit, 2014. They are permitted in public foray so as long as they're narrowly tailored to serve a significant government interest, leave open ample alternative channels for communication of the information, and do not delegate overly broad licensing and discretion of government officials. Long Beach Area Peace Network versus City of Long Beach, 9th Circuit, 2009. Quoting Clark v. Commentary for Non-Creative Nonviolence, 1984. and so forth, so forth. In contrast, restrictions on speech in non-public forum must only be reasonable in light of purpose served by the forum and viewpoint neutral. So we're starting to get an idea that these judges really smacked down on the DHS, saying this needs to go to trial. These restrictions need to be defined. What are the facts? We need understanding of what is going on here. But as is, that is what I just wanted to cover, and we'll go ahead and sort of scroll down here real fast to this. For foregoing reasons, we vacate the district court dismissal of plaintiff's First Amendment complaint and remand for further proceedings. Costs shall be taxed against the defendants, appellees. So pretty much everybody's still got to pay for their fees and all that stuff, but they're stating that this will continue on. This needs to continue on. The judge is good at shooting this fool down with his argument. Yeah, it's quite. The judges did one hell of a interesting job, just like going, "Hey, yo, okay, what's the reason here?" And then pointing out the contradictions in his arguments that he's pointing out. That is all I got for this part. I'll have a link to the description of all the information I've researched so far. And as you can see, literally there isn't really much information that details where their property begins, where it ends, at least with the tax maps that we're looking at. This really needs to go before a court and be decided. And this is going to play future important roles, I suspect, when it comes to border patrol areas, or at least ports of entry. I see this playing a big issue with ports of entry. Paper tape and literally inscribed in stone storage seems to be pretty temporary, yeah. So, as is, I am pretty well tuckered out from doing all this research and putting all this together. Any questions from you guys about this? Thoughts, opinions before I sign out? Dual backups for everything. Hard drives are cheap compared to data recovery. They're cheap, but just not cheap enough for me, and I'm constantly running low on storage. and in order to sort of improve on storage, I really love RAID configurations, because if something happens, usually you can rebuild the data in most situations. I think it's RAID 5. And also, a little side note, do expect that my activity, once I start up college this fall, to sharply go into a downturn of low activity, at least on this channel. I might just do a bunch of live streaming where I'm doing my homework, and you guys can learn with me. Had 3 talking points and failed. Yeah, he didn't really do so great on the talking points, that is for sure. If Google take all the photos, why can't anyone else? Sorry. Oh, and before I quickly forget, if anybody is wanting to drone this area, this is Class D airspace because of 2 locations. You got an airstrip here, and there's another one over here. And with you can see these blue line outlines here. These mark Class D airspace, requiring require permission from air traffic control to fly in those areas. It was just something I was keeping in mind for maybe something trip or something, whatever I have in my mind in the far future. Yeah, as is, this is something we're definitely going to want to keep an eye on. And if also, to any of those guys in the audience, reach out. All the California auditors that have been active in this area and have had issues, give them a heads up about this case, please. Especially those that were at this border bridge right here that got shoved off. Make sure they get I did put out a text message, the time to stand at least, to let him know about this case. Of course, that was at midnight, so... Take your logo down so we can see. Oh, I don't have the camera set up as is, and I need to go get a haircut. So, Bunny Boots may set up Pornhub channel and save backups there. Yeah, well, I have BitChute actually to do backups for videos. It doesn't automatically save the live streams though. But I'm not really too concerned on some of the live streams because they're literally just coverage of this kind of stuff. But anyway, I'm going to go ahead and call it a night. Thank you all for tuning in. I hope you guys got quite the knowledge beef up on this part. And shortly afterward, it also allowed me to test out something with behind the scenes on setting up this specific live stream because I set it up as an event. I'm sort of trying to figure out some stuff on the back end of things, some new changes that how to do things differently with live streams that might improve the opportunity of people getting notifications. It's just I got to test out if I can properly do it from the cell phone and mobile devices and how all that stuff will interact with all the other stuff. So, but you guys have BBI $10 a month gets unlimited on Prime. I'll have to check that out. But anyway, you guys have a nice day and good night for me. That's for sure. I'm gonna try to get some sleep here in a little bit.